Okay, good evening everybody, and welcome to the launch of the second annual Daniel Webster Debate Series. This series, as I'm sure many of you know, is dedicated to Daniel Webster, one of the greatest orators, public servants, and lawyers this nation has ever known. Webster's rhetoric was so powerful that it once famously brought Chief Justice John Marshall to tears during oral arguments on a case of corporate law. And as someone taking corporations right now, I can certainly sympathize. The series was founded just last year by Brady Marsden, with the goal of bringing leading judges, scholars, and practitioners from across the country to debate the most pressing issues of our time. In only 1 year, it has become the heartbeat of our chapter and a cornerstone of the intellectual conversation in the center of the very city where so many issues are made. And so, we know we had to continue the tradition this year, especially since the issues of our time certainly haven't gone to rest. If anything, in the past several months, many have only intensified and many new ones have emerged. That's why I'm thrilled to open this year's series with a debate on a topic that not only permeates Second Amendment jurisprudence, but is shaping the jurisprudence of the modern court as a whole. The move from tiers of scrutiny to historical analogs for constitutional rights is one that has even divided members of the Federalist Society, like those before us today. So, without further ado, to introduce the three distinguished panelists who will take up this challenge, please join me in welcoming our Director of Debates, Louis Fung. Thank you so much, everybody.
Good evening, everyone. Our moderator is Judge Thomas Hardiman, who was appointed to the United States Court of Appeals for the Third Circuit and was confirmed by the Senate on March 15, 2007. Prior to becoming an appellate judge, Judge Hardiman served as a trial judge on the United States District Court for the Western District of Pennsylvania. In 2008, Chief Justice Roberts appointed him to the Information Technology Committee of the Judicial Conference of the United States, and he was the chairman of the IT Committee in 2013 and served in that capacity until 2021. Before entering judicial service, Judge Hardiman handled a wide variety of litigation matters in state, federal, and appellate courts as a partner at Reed Smith, Titus & McConomy, and as an associate at his predecessor firm. He began his career in the Washington, D.C. office of Seattle. A 1987 honors graduate of the University of Notre Dame, Judge Hardiman received his law degree in 1990 from Georgetown University Law Center, where he served as a notes and comment editor for the Georgetown Law Journal. Judge Hardiman regularly teaches a seminar on advanced constitutional law and teaches a one-week course entitled Constitutional Law, the First and Second Amendments at Georgetown University Law Center. A native of Waltham, Massachusetts, Judge Hardiman has chambers in Pittsburgh, Pennsylvania, where he and his wife, Lori, reside. They have 3 grown children. Distinguished University Professor Nelson Lund at Scalia Law School is the author of Rousseau's Rejuvenation of Political Philosophy, a New Introduction. He has also written widely in the fields of constitutional law, including articles on constitutional interpretation, federalism, separation of powers, the Commerce Clause, the Speech and Debate Clause, the Equal Protection Clause, the Uniformity Clause, and most importantly for tonight, the Second Amendment. In addition, he has published articles in the fields of employment discrimination and civil rights, the legal regulation of medical ethics, and other topics. Professor Lund graduated from St. John's College in Annapolis, Maryland, after which he received an MA in philosophy from the Catholic University of America, a PhD in political science from Harvard University, where he then left the faculty of the University of Chicago to attend its law school and served as the executive editor of the University of Chicago Law School and the chapter chairman of the Federalist Society at Chicago. After law school, he held various positions within the government and clerked for Justice O'Connor on the Supreme Court. Professor Joel Alicea is the inaugural St. Robert Bellarmine Professor of Law and Director of the Law School Center for the Constitution and the Catholic Intellectual Tradition. He has also served as visiting professor at Duke Law School and Notre Dame Law School. Prior to joining the Catholic Law faculty, Professor Alicea practiced law for several years at the law firm of Cooper & Kirk, where he specialized in constitutional litigation. He previously served as a law clerk for Justice Alito. Professor Alicea's scholarship is focused on constitutional theory. His scholarship has appeared or is forthcoming in the Yale Law Journal, the University of Pennsylvania Law Review, the Virginia Law Review, and the Notre Dame Law Review, among other publications. He has also been active in public debates about constitutional law, testifying before Congress and publishing essays in places like the New York Times, the City Journal, and National Affairs. And with that, I hope we have an excellent debate.
Judge Hardiman, if you can please introduce the topic for us. You can either come up here, down there, up to you. Thank you so much, guys.
All right. Tonight we're going to ask the question, is Bruen's history and tradition test for the Second Amendment workable? It's a great honor for me to be here with these two very distinguished scholars of the law. And it's also a special treat because often when I'm moderating these debates, we're considering the question presented from two very different perspectives. The premises often don't align. You often have a living constitutionalist against a textualist, or someone who views himself as a practical Justice Breyer type against a textualist. But today we have two who I think would fairly describe themselves as originalists, serious textualists. They take the Constitution seriously. So it's a great opportunity for you all, I think, to see how methodology of judicial decision-making doesn't always conduce to agreement or easy answers. It just often presents layers of subtlety and difficulty. So I think you're in for a real treat tonight. I just have to set the table and sort of keep the time, so I have the easy job. I'm going to give you a very, very brief primer as to where we are on the Second Amendment. As you undoubtedly know, the Supreme Court decided the landmark decision in Heller in 2008, invalidating a DC law that was challenged by Dick Heller. Because that only affected the District of Columbia, it didn't do anything really for gun rights in the 50 states, which brought us to the case of Otis McDonald out of Chicago in 2010. And in that case, the Supreme Court held, applying substantive due process, that the Second Amendment is incorporated against the states. The opinion was written by Justice Alito. Quite a fascinating opinion, especially when counterbalanced with Justice Thomas's very lengthy dissent. Justice Thomas, concurring opinion, not dissent. Justice Thomas's concurring opinion, I think, is one of the most interesting things he's ever written as a justice on the court. It's a real sort of takedown of Justice Alito's reliance on substantive due process. Justice Alito doesn't engage too much with Justice Thomas's exhortation to apply the Privileges and Immunities Clause. Instead, Justice Alito relies on precedent, saying, well, the slaughterhouse cases have been around for a long time, so substantive due process does the work here. So those two landmark decisions really gave us on the inferior federal courts a tremendous amount of work to do. It was great fun because we're writing on a blank slate. When I was sitting here at the Law Center, where you are now, we didn't take a course on the Second Amendment. It wasn't included in constitutional law. It was a non-issue. But it quickly became an issue after Heller and McDonald, and it led to a series of very interesting cases I won't bore you with now because it would take too long. But suffice it to say that the lower courts really struggled with interpreting Heller and McDonald for well over a decade because Bruen wasn't decided until 2022. In the interim, there was one little case, which is really fun to read. It's really short, called Caetano. It's a case out of Massachusetts where the Massachusetts Supreme Judicial Court upheld a conviction of a woman named Jamie Caetano. It was a really crazy case. Professor Barnett would not have prosecuted this case when he was a prosecutor in Chicago. Jamie Caetano was an abused girlfriend. The father of her child was very physically abusive, dangerous. She got a stun gun, and she defended herself with a stun gun and was prosecuted for using the stun gun. And the Massachusetts Supreme Judicial Court upheld her conviction. The Supreme Court undid that in 2016 and said, really heavily criticized the Massachusetts Supreme Court, saying, look, your interpretation of history and tradition in Heller and McDonald is totally off base. We did not write an opinion saying that if stun guns didn't exist in 1787, then you can't have a stun gun in the 21st century. But that opinion really didn't do much for us on the lower courts because we didn't have cases involving stun guns. We had other cases involving the three difficult questions of who, what, where under the Second Amendment, and I'll elaborate on that briefly in a minute. So in the interregnum between McDonald and Bruen, we had a lot of work to do. We had a lot of interesting cases. And then Bruen, we thought, gave us pretty clear marching orders, but then 2 years later in Rahimi, the Supreme Court went a little bit in a different direction. I think you're going to hear more about that from our debaters here. Query whether it's consistent with Bruen or not. But Rahimi was obviously a very important case as well. The last thing I'm going to say to set the table is that Bruen really gave us a two-step methodology. When I said that we got our marching orders from Bruen, at step one, we had to ask the question, who, what, where? So a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, who are the people? Does it include everyone? Does it include people who are visiting the country? Does it only include citizens? Do you have to be over a certain age? That's the who question. The what question, arms, keep and bear arms. What is an arm? And then, of course, the where question. Can you bear arms anywhere? Some argued, in fact, in a case that we decided out in New Jersey where I dissented, my colleagues held that the New Jersey law, which required people in New Jersey to show a justifiable need to carry a gun in public, our court said that that was valid. I wrote a long dissent saying that was not valid. And the reason it was not valid, in my opinion, was because the word bear in the Second Amendment has to do some work. Keep and bear arms does not mean you have a right to carry a rifle or a handgun in your living room and march from one end of the living room to another. The right to bear arms has to mean something more than that. I contended in that dissent in a case called Drake versus Filco. And that sat there for a long time. That minority view that I and some other judges in the country had written sat there for a long time until Bruen came along in 2022. So the first step one is a semantic question, who, what, where, and then step two, which is where most of the action is right now. The Supreme Court told us to apply history and tradition. If the who, what, where question is satisfied, then the burden shifts to the government. The government has to come forward and justify the regulation by some historical analog, not a historical twin, but a historical analog, something that is, quote, relevantly similar from the early days of the Republic. And that's what happened in Rahimi. In Rahimi, the court said, well, the law that said Zaki Rahimi was not entitled to a firearm was relevantly similar to old laws that were called affray laws, going armed laws, also called affray laws, and surety laws. And that's a subject that I think you'll hear some debate about tonight. So those are the basics, a very thumbnail sketch of the foundation here. And now I'm going to turn it over to Professor Lund for his opening remarks.
Thank you. It's an honor and a privilege to be here, especially with this very distinguished group of speakers. I've been asked to argue that the Bruen test is not workable, and I've been asked to speak first. So I want to start by stressing an important way in which Bruen's history and tradition test is perfectly workable. Sometimes that test is the best way to identify the original meaning of the Second Amendment. By the way, can you hear me in the back? Can this thing be turned up? Let me go back there. Sometimes the test is the best way to identify the original meaning of the Second Amendment. In Heller, for example, the overwhelming weight of textual and historical evidence showed that the Second Amendment protects an individual right, not a right of the states to maintain a militia. Bruen itself provides another example. The challenge statute effectively eliminated the right to carry a handgun for self-protection. the text and historical record strongly confirmed that that violated the Second Amendment. Now, in theory, the Bruen test could be applied in every case, but the court has not been willing to do that. Instead, the court has interpreted Bruen in a way that effectively adopts a different test. Unfortunately, the new test is the same test that Bruen purported to repudiate. If there's time during the question period, I can sketch a better approach which the court should have adopted. The Bruen court was faced with a genuine problem. Heller's specific holding, which invalidated DC's handgun ban, was issued without a supporting analysis based on history or original meaning. In addition, Heller gratuitously approved several modern gun control laws without any legal analysis of any kind. The lower courts quickly recognized that Heller had not given them clear guidance for future cases. Over the next 14 years, those courts effectively adopted the watered-down version of intermediate scrutiny that Justice Breyer had used in his Heller dissent. Bruen emphatically and rightly rejected this kind of freestanding interest balancing. Instead, Bruen expressly held, and I'm quoting, that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Now, as I mentioned, this text and tradition test is a very workable tool for identifying the original meaning of the Second Amendment in some cases, such as Bruen itself. Bruen sought to make the test work for a wide range of closer cases or more difficult cases by instructing courts to uphold a modern regulation only if it is analogous to a regulation in the historical tradition. And the court set forth criteria, or a criterion, for identifying a tradition, where a government practice has been open, widespread, and unchallenged since the early days of the Republic. The practice should guide our interpretation of an ambiguous constitutional provision. The court also explained how to determine whether a modern regulation is analogous to a regulation in the historic tradition. It must impose a comparable burden on the right to armed self-defense and must do so for a comparably justified reason. Now, in 1791, and for many decades thereafter, Americans could keep any kind of weapons they wanted to, including cannons and other military weapons. And they could take their weapons almost anywhere they wanted to, so long as they did not misuse them. So the actual tradition was one of no regulation or absolutely minimal regulation. I think there was never any chance that this court would try to restore that tradition. But how can modern courts judge a regulation's consistency with a regulatory tradition that contained virtually no regulations? In dicta, Bruen argued that some modern regulations can be justified by analogy to historic bans on carrying weapons in what Heller and then Bruen called sensitive places, like legislative assemblies, polling places, and courthouses. But that argument collapses when you read the law review article on which the court relied for its historical analogies. The article provides no examples of gun bans in American courthouses. It cites one 17th century colony that banned weapons in legislative chambers, and it provides only one example of a regulation from the early days of the Republic, namely a state ban on bringing weapons to polling places. If one or two isolated regulations can constitute a widespread and unchallenged tradition, then Bruen's words just don't have much meaning. A different example of Bruen's disregard for its own holding is provided by a dictum that endorsed so-called shall-issue licensing laws. The court provided no evidence of any tradition requiring any kind of license to carry a gun. Bruen then acknowledged that such regulations could be used to serve abusive purposes, which could render them unconstitutional. That's exactly the kind of freestanding interest balancing that Heller and Bruen condemned. The court's most recent decision effectively adopted the malleable form of intermediate scrutiny used in Justice Breyer's Heller dissent. Rahimi upheld a statute that criminalizes the possession of a gun by anyone subject to certain domestic violence restraining orders. The statute does not require proof that the subject has violated any law or misused a weapon in any way or engaged in any act of violence. The court did not cite a single historical law forbidding Americans to keep a gun in their own home, even if they had been convicted of a violent crime. Rahimi nevertheless upheld the statute on the basis of two historical analogs. First, surety laws that allowed courts to demand a bond when there was probable cause to fear future misbehavior of various kinds. Second, anti-affray laws that made it a crime to terrorize the public by going about with dangerous and unusual weapons. Neither of these laws prohibited anyone from possessing whatever weapons they chose to possess. Neither of them prohibited people from carrying their guns in public. So neither one is remotely comparable to the statute at issue in Rahimi. The court argued that the anti-affray law imposed a comparable burden because those convicted of violating it could be imprisoned. It's a kind of greater includes the lesser theory. So on the court's reasoning, the government can forbid you to keep a weapon in your own home if you are accused of doing something dangerous that could conceivably land you in jail. A speeding ticket could be enough. In fact, it's enough to threaten something dangerous even if you haven't done it. So threatening a minor child with corporal punishment could be enough, and so could threatening to put a caustic substance on the steering wheel of your husband's car. Maybe the court will never endorse such results, but Rahimi's reliance on what it calls common sense and on far-fetched analogies effectively substitutes Justice Breyer's freestanding interest balancing for Bruen's history and tradition test. By forcibly reworking Bruen's test into the very thing that Bruen itself emphatically denounced, the Rahimi court proved that it is unworkable as a practical matter, even if courts and commentators feel compelled to pretend that it hasn't been abandoned sub silentio. Thank you.
All right, Professor Alicea.
Sorry, I speak from. Well, as one of those who pretends that Rahimi did not abandon Bruen's methodology, I suppose that the challenge has been laid down for me. I'll begin by thanking everyone for being here. Thanks to the Georgetown Federal Society for hosting me, to Judge Hardiman and to Professor Lund for participating in this event. It's a great honor for me to be here with them, and to some of my students from CUA who are here for moral support. I appreciate that. It seems to me that a lot of Professor Lund's criticisms boil down to contingent historical disagreements with the court's analysis that he then blows up into methodological disagreements, like takes disagreements about how to read the history and makes it into a disagreement with the methodology broadly speaking. And I think that it's important to distinguish between genuine challenges to the theory or concept behind Bruen's two-step approach, his text and history approach, from contingent disagreements about, well, how is it applied? Is it applied appropriately or not? And I think a lot of what Professor Lund was saying was that he just disagrees with how it's been applied. I think he wants to make the further point that because it hasn't been applied as he thinks it should be, if you're going to apply it historically accurately, that impugns the methodology itself, because the methodology itself is proven unworkable if it doesn't cash out in the way that he thinks would be the most historically accurate way to do so. But I think that really is just kind of conflating a contingent disagreement about how the history works with a larger debate about methodology. There is nothing theoretically or conceptually flawed about Bruen's two-step approach. It seems like Professor Lund is on board with step one, that he didn't raise any, I think, real disagreements with that we're going to first look to see textually, as a matter of original semantic meaning, are we dealing with a person who's part of the people? Are we dealing with an object that is an arm? Are we dealing with conduct that is keeping or bearing that kind of object? And that makes a lot of sense that we would start with that, because if you look at the debates of the first Congress, it's very clear to me that they were trying hard to draft language that, in its concise way, would capture as closely as possible the pre-existing understanding of the right at the time, both on the Second Amendment, but other rights that were pre-existing natural rights like free speech and free exercise. So we should take the text seriously, and violation of the underlying text, I think, should give rise to a presumption that you violated the underlying right that the text is declaring and recognizing. And so the burden shifts to the government then. At step two, if we're going in with a presumption that the government has violated the underlying right, we then go to step two, and the government's job is to come forward with historical evidence showing that there were pre-existing limitations on the right that would support what the modern regulation is trying to do, right? And those are both on the how and the why sort of dimensions that Judge Hardiman mentioned as part of step two. It seems to me that a big source of disagreement between me and Professor Lund is just the level of generality at which you're defining those principles at step two. And he keeps pointing out, there isn't a law that looks like the law at issue in Rahimi, for example, in this specific respect or in that specific respect. I think that just kind of begs the question, because the whole debate is over, well, at what level of generality should you define those historical analogs and the historical tradition? And to the extent that those specific features that he thinks readily distinguish this federal statute in Rahimi from those analogs are in fact irrelevant distinctions, then that doesn't impugn Rahimi's analysis at all, right? So I think you'd have to do more than simply point out some distinction between a historical tradition and a modern statute that's being analyzed, because the whole work is figuring out what features of a historical analog and of a historical tradition are legally relevant in analyzing a modern regulation. Now, in my article, Bruen was right. I've tried to lay out a way to do that. How can you set the level of generality in a way that isn't arbitrary, that is actually principled and rigorous? And it seems to me that the best way to do this is to try to adopt a kind of internal perspective from the ratifiers, to immerse yourself enough in the history to understand how they understood the right, and then to reason from that to analyzing whether particular features of historical laws or historical tradition are actually part of the right or are just contingent incidental features that are subject to change. So just to give like a kind of a trivial example, the fact that a law was enacted on a Tuesday, that is a fact about that law. It's a feature of that law. But it would be very difficult to argue that as a matter of original meaning, the fact that some law was enacted on a Tuesday is part of the right, and therefore any subsequent modern law has to also have been enacted on a Tuesday to be relevantly similar, right? The question should be on the how and the why dimensions. Would this particular feature be seen as normatively salient by the ratifiers or not? And that's a historical inquiry that requires normative analysis, reasoning from historical premises, right? Is that going to require judgment calls? Of course it will. But it is a fundamentally different analysis than the tiers of scrutiny, which I think Professor Lund and I both criticized pretty significantly. And I agree with him in saying that Bruen was right to reject the tiers of scrutiny analysis. It's a fundamentally different inquiry from the tiers of scrutiny, from intermediate scrutiny, because it's comparative exercise where I'm comparing some sort of historical baseline with the modern regulation and attempting to discern whether these two are, as Bruen says, relevantly similar. That is not tiers of scrutiny. Tiers of scrutiny is whether I, the judge, think that an interest is compelling, quite apart from any historical baseline. Williams-Uli explicitly rejects the use of historical tradition as supplying the way in which you can cabin or identify what is the compelling state interest. On the means, again, we are comparing historical analogs with the modern regulation. That is fundamentally different from the tiers of scrutiny, where I, the judge, am discerning whether I think that reducing the amount of ammunition in a magazine will reduce mass shootings by any significant amount, right? That kind of complex empirical analysis is just up to me as a judge, right? As opposed to the kind of comparison between history and the modern regulation. So I just think that it is not right to say that the judgment calls that are involved in step 2 of Bruen is the same as the tiers of scrutiny. They're different in kind, even if there is room for discretion in drawing those analogies. And I would say that I think that we should be careful about how far we take the kind of argument that Professor Lund is sketching, because that kind of argument, if accepted, would seem to defeat almost any historical methodology. Because there's almost any historical methodology is going to require some amount of judgment about whether a particular piece of history is relevant to whatever we're analyzing today. Bruen tries to make that a little more step by step. It tries to concretize it in a way that makes it more readily applicable by the lower federal courts. But there's nothing inherent in the Bruen methodology that is different from a normal, conventional originalist analysis. It attempts to actually just do originalism in more step-by-step form. So if you're going to say that because you disagree with the judgment call that's made about the level of generality on this case or that case, that just means it's no different from the tiers of scrutiny, then originalism is no different from the tiers of scrutiny. And they're both fatally flawed methodologies, which is what a lot of people think, but usually not what originalists think. Thanks.
All right, give Professor Lund a chance to respond.
Okay, I think I think a lot of what you just said is not in disagreement with anything I've said. In theory, at some great level of abstraction, the Bruen test could apply everywhere. And I think it does apply in some cases. It applies very well. In the threshold question in Heller, in the case, the issue at stake in Bruen, and some other cases. It's not as though this history and tradition test is always unworkable. The problem is, how is it going to work when there is no relevant history? There are no analogs, reasonable analogs. And these are not just, I think, just not judgment calls. To say that a modern statute that completely strips you of your Second Amendment rights on the basis of virtually no evidence, which is what can happen in these domestic violence cases, puts no more burden on the right than an anti-affray law or a surety law, which left you free to keep whatever weapons you wanted in your own home and for the most part to carry them wherever you wanted. To say that those are similar burdens just seems to me as not a question of a judgment call about the validity of analogy, but it's turning human reason upside down to suggest that. I don't think there's a problem, and I don't think I've taken the criticism of Bruen too far. I've taken it only as far as it appropriately goes to show that it's effectively substituting a version of intermediate scrutiny, because Chief Justice Roberts in Rahimi says, well, common sense tells you that the government should be able to stop future violence. And Professor Alicea basically says the same thing in his law review article. He says, well, namely modern legislatures and courts, I guess, have different risk preferences. We have different ways we think of discouraging violence, and so and so courts should let legislatures do things like what they did in the statute at issue in Rahimi. Well, that's not based on history. That is effectively Breyer interest balancing, dressed up with some inappropriate or far-fetched analogies, I think.
So on that last point, and then I'll work back. It isn't true that in my article, at least, that I say that because we have different risk tolerances, we should be able to just go further than some sort of a historical analog. The point of the analysis is to show that that surety and fray laws are relevantly similar because they don't have any sort of features that distinguish them that make them not part of the same tradition. They are part of a continuum of historical regulation, which then offers the modern legislatures the freedom to decide where to draw the line in terms of risk assessment. But that's a historical analysis that then informs how far the legislature can go. It's not a free-wheeling normative analysis, and neither is the Chief Justice's opinion, actually, Rahimi. What you were quoting earlier, he says that the history confirms what common sense would tell you, right? It doesn't just start from my own kind of Chief Justice commonsensical notions, although he's happy to do that in a lot of other cases, but not in Rahimi. In Rahimi, he does actually try to ground it in history, just not very rigorously. Like the majority opinion in Rahimi, I will fully, agree with a lot of criticisms that you might offer of that majority because it skips over all the difficult work. The majority opinion does not engage with questions about levels of generality. It does not engage with a lot of the distinctions between surety and fray laws and the federal statute that Justice Thomas identifies in dissent. I think there's a pretty obvious reason for that, which is that the majority opinion Rahimi is trying to keep together a coalition of everyone except Justice Thomas, and that means that it would be very difficult to sort through and decide very complex methodological questions like how to set the level of generality under Step 2 of Bruen and maintain that coalition. But that doesn't, even though it makes sense that that's why the majority opinion doesn't dive into any of this the way I do in my article, that still doesn't make it any more satisfactory as a majority opinion, so I agree with that. I'll just say one last thing and we'll open it up, but I don't think, now here I'm happy to concede that Professor Lund is, he's much more knowledgeable about the history than I am. But even conceding that, I just don't think that's true to say that there was just an absence of regulation and an absence of historical analogs at the founding with respect to firearms. There's quite a bit actually in the common law tradition that supports what have become very common features of modern regulation, both as to who can possess firearms, where you can carry them, and what you can possess. And both Heller and Bruen, I think, try to outline what those different historical analogs are. Again, I think that you're just disagreeing about the level of generality at which they're defining those and the principles that they're deriving from those historical examples.
That might be a good place for me to interject because I think this question of relevantly similar is key here. And what I heard Professor Lund say is consistent with, frankly, what we've seen from the government in these cases under Bruen, where the government has not yet, in trying to carry its burden at Step 2, produced any sort of series of 18th century regulations that showed a permanent dispossession of a firearm. Basically, it appears that there were two ways in the late 18th century to dispossess somebody permanently: execution and life imprisonment. Were there others?
Not that I know
No,
of.
not that I know.
All right. Well, so then, what I hear Professor Lund saying is that where the rubber meets the road here is, are you permanently dispossessed from having a firearm? And a challenge to you, Professor Lund, in terms of what Professor Alicea said about some of the regulations that did exist. The historians that we've heard from in academic settings have told us that it was much more of a communitarian normative thing. The village idiot, for example, was not allowed to keep his gun. The village idiot, if he was acting like the village idiot, would be quickly or the drunkard, or the wayfarer, the hobo, they would be quickly and immediately disarmed by the community. but it would not be a permanent dispossession. Is that your understanding of the early regulatory tradition?
Well, I don't even believe that there's anything analogous to Section 922G8, which is what was at issue in Rahimi. People, as far as the law went, there were no laws, no regulatory tradition of taking people's guns away from them and saying you cannot keep a gun in your home, or even you can't walk around with a gun. I just don't know.
Not even temporarily. But is it your contention that it had to be ensconced in law? It couldn't have been the local constable or the mayor had the power to dispossess the dangerous person for a period of time?
That could be as a matter of kind of informal practice. Yeah, sure, that could be. But a regulatory tradition that is not embodied, so to speak, in law is a very strange kind of tradition to use to undermine the constitutional right to keep and bear arms in the Second Amendment. It seems to me they just seem not to have been interested in doing that. Now, you could be punished for misbehavior. That's for sure. That's what the anti-fray laws did. They punished you for doing something. Those are. An affray is basically an assault. It's an assault on the public, and you can be punished for that. You can go to prison. And incidentally, of course, you're not going to be allowed to keep your weapons while you're in prison. But as soon as you're out, you're back at home, you can have your weapons. And to say this, the Chief Justice has concludes the lesser argument, which is, well, if you can take their guns away from them in prison, then you can take them away for anything that might lead to prison. I mean, it's really not, I think, an argument to be taken serious.
Okay, but that's not his argument, right? He doesn't say that you can take away their arms for anything.
No, he does not follow that up with the natural conclusion of the argument he makes. That's right.
Well, no, because the argument that he makes isn't what you said it was. He says that a fray justifies temporary disarmament because a fray involves a finding of dangerousness. This person was dangerous. That assault on the public is the finding of dangerousness. And it was a consequence of that they're temporarily disarmed through imprisonment. In the case of Section 922G8, in that case, there is a specific finding of dangerousness that supports the domestic restraining order. And the Chief Justice was saying that sort of conduct is what gives rise to temporary disarmament. It doesn't have to require a conviction to give rise to temporary disarmament. That's true. But it's not that you can just do anything like jaywalk and be temporarily disarmed. That doesn't follow from what Rahimi says.
In fact, 922G8 does not require any real evidence of dangerousness. The person subjected to the court order doesn't need to have broken any law. There doesn't have to be any evidence that he was dangerous, he did anything dangerous, threatened anything dangerous. All it requires is that somebody asked for a restraining order, and the judge writes down he poses a clear danger of violence to his intimate partner or her child. That's all it requires. That's all it requires. And in the Rahimi case itself, we don't know exactly what happens because one of the important records is not publicly available as far as I can tell. But the court painted Rahimi as a really bad, dangerous guy, which may be true, may very well be true. He was, I think he was under indictment for several serious crimes at the time the court issued its decision. But it relies for the claim that he was dangerous at the time that the restraining order was imposed entirely on cites to the government's brief. And when you go look at the government's brief, they don't actually have any evidence. What they do is cite what they call the ROC, which I assume is probably the record on appeal in the Fifth Circuit, but that seems to be unavailable.